writing. The petitioner is questioning the annexure M, the order passed by the respondent number 3, reholding of my lord's exams. That is at page number 243.
What is annexure M?
Annexure M is the respondent number 3. Herein my lords conducted a preliminary exams, and thereafter my lords he received certain my lords objections from the candidates, and as per the direction of a CM, lords he cancelled the earlier preliminary exams and direction is issued to hold up fresh exams. That is the fresh preliminary exams as per annexure M, my lords. Lords, here my lords the facts of this case are lords on 26/2/2024. Lords, the respondent number 3, my lords, invited an application for calling upon of 384 guested posts. Lords, the petitioner herein is aspirant and filed application. Lords, in view of certain technicalities, my lords, the exams were extended from time to time, almost for 3 to 4 times. Lords, the exams were extended. Lords, lastly on my lords 22/8/2024, exams were conducted. Prelims exams in part 1 and part 2 they conducted exams. Lords, after conducting exams, my lords, on the very same day, my lords, the candidates can file objections if there are any my lords mistakes in the lords answers. That is the key answers they will do. They can file objections. Lords, thereafter, my lords, the matter went on. Subsequently, my lords, the respondent number 3 alleges. Lords, certain candidates, my lords, went on a strike, holding that my lords, there are certain mistakes in the Kannada key answers. And based upon that, my lords, the CM directed to rehold the exams, that preliminary exams. Based upon that, my lords, now the annexure M came to be passed. Lords, my submission for my lords is first and foremost. Lords, this respondent number 3 is in a constitutional body. Lords, under Article 315 and 320 provides for its powers how to be, my lords, the other functions. Lords, now based upon the CM's oral direction as well as CM's chief secretary has addressed the letter at annexure K, directing, my lords, that annexure J is the, my lords, Twitter of the CM. That is at page number 238, 239 is a type of copy. 239 is a type of copy, my lords. In the light of the report of incorporated Kannada translation questions in the Kpsc guested provisionary exams, I have directed Kpsc to reconduct the exams within 2 months to ensure fairness to all the candidates. Lords, this is the Twitter of the CM. My lords, next page 240. This letter is addressed by, my lords, the chief secretary. Respondent number 1 herein.
Responsible for these labs have been relieved of their duties.
Lords, lapses.
239 ali, those responsible for these labs.
No, they have not been removed. No action has been taken against them.
Upcoming examination will be conducted with utmost responsibility and accountability.
Please.
Following all due diligence.
Please. No action has been taken against those officers who have done mistakes, my lords. That is.
What is the next document, Chief Secretary?
Chief Secretary, my lords, has addressed the letter to, my lords, the respondent number 3. Lords, as per the direction of, my lords, the CM, lords, Chief Secretary directed to reconduct exams. That is at the last paragraph of that 240. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿ ಆದೇಶದಂತೆ ತಪ್ಪಿತಸ್ಥರ ಬಗ್ಗೆ ಒಂದು ವರದಿ ನೀಡಲು ಸೂಚಿಸಿತು. ಅದರಂತೆ ಅವರ ಬದಲಿಗೆ ಬೇರೆ ವ್ಯವಸ್ಥೆ CS ಇಲಾಖೆಯಿಂದ ಮಾಡಲಾಗುವುದು. ಅಲ್ಲದೆ ಮುಂದಿನ 2 ತಿಂಗಳಲ್ಲಿ ಭಾನುವಾರದ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದಿಂದ ಮರುಪರೀಕ್ಷೆ ನಡೆಸಲು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ತಮ್ಮ ಅನುಮಾನ. This is the report. Notes, based upon this, my lords, even, my lords, according to the now the respondent have filed, my lords, the objection. Notes, in the objection they have produced the annexure R1. Notes, they say they have received, my lords, the expert committee report, but that expert committee report is not produced. Next page is, my lords, a paper cutting which I cannot rely. But notes, there, my lords, the expert committee report was disclosed in the paper. Notes, there they never say there was any such serious lapses on the part of the any officers or there was any malpractice. Only, my lords, they say there are certain mistakes that cannot take any chance, my lords. Before this, my lords, I want to take for a moment. Lords, the page number for 78. This is the hall ticket issued by the my lords, the respondent number 3. Page 78, my lords. Notes, next page, notes 79. Notes item number 14 for a moment. ಪತ್ರಿಕೆ 1, ಪತ್ರಿಕೆ 2 ಪ್ರಶ್ನೆಗಳು ಕನ್ನಡ ಮತ್ತು ಆಂಗ್ಲ ಭಾಷೆ ಎರಡರಲ್ಲಿಯೂ ಇರುತ್ತವೆ. ಕನ್ನಡ ಭಾಷೆಯಲ್ಲಿ ಇರುವ ಯಾವುದಾದ್ರೂ ಪ್ರಶ್ನೆ ಭಾಷಾಂತರದಲ್ಲಿ ಏನಾದರೂ ಗೊಂದಲವಾದಲ್ಲಿ ಅಭ್ಯರ್ಥಿಗಳು ಆಂಗ್ಲ ಭಾಷೆಯ ಪ್ರಶ್ನೆಗಳನ್ನು ಸಹ ನೋಡಿಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನು ಅರ್ಥೈಸಿಕೊಳ್ಳತಕ್ಕದ್ದು. Notes, this is what notes the hall ticket itself discloses. If there is any ambiguity in the notes the questions, confusion, they can look into the Kannada and they are required to write. Notes one is
Kannada. If there is any kind in Kannada, then they can look at English.
This is
write their answers.
Notes one, my lords, booklet which I have produced at annexure G, page number 84, my lords. 84. This is the my lords the question paper booklet. Notes in the here, my lords, item number 7, page number 84, my lords. My lords, here also, my lords, this is 87 is in, my lords, I will take, my lords, the same annexure last page, that is at page number 155. This is the entire booklet of, my lords, question paper 1. Page number 155, my lords, clause number 7, my lords, for a moment.
That's in English.
It is in English, my lords. Questions are printed in both English and Kannada. If there is any confusion in the translation of a Kannada questions, the candidate shall refer to questions in English, understand the question. So this is what, my lords, the notes hall ticket, question paper 1, notes question paper 2. Notes even question paper 2 also same, my lords, that is at page number 158.
All right, now what is the question? What is the confusion?
Confusion is that, my lords, here, my lords, before declaring a results, notes the respondent number 3, my lords, there are certain corrections, my lords, that the translation mistakes, cancel the exams and notify the fresh exam.
What is the question and what is the confusion?
Notes, that is not there in their statement. Nothing they have, even they have not produced the report for this court. No such things, my lords. What are the objections received? Which are the incorrect?
I have written the exam.
Please, my lords, I have written in English.
So this paper 1 is what subject? What is it?
This is, my lords, this is the paper 1, my lords. This is all being, my lords, prelims exams question and answer, my lords.
All right. So what is that question which has created confusion in Kannada?
Lords, it is, my lords, according to me, there is no any mistake.
No confusion.
No confusion.
So confusion is with Kpsc.
As per the same direction, this is one.
The paper, the third response note. But the first primary ground note urged by the petitioner is not
If re-exam is conducted, whether you will be eligible or
No, sir, till result is not at all announced.
but results are
If result is announced, if any candidates will come forward, then it could be understood. Here, before announcing results itself, my lords, KPSc itself has declared, my lords, re-exams.
but,
That cannot be done. That is covered by.
well, if this re-exam is held, does it change the pattern and that is change the number of
no,
participants?
nothing.
No fresh persons will come in.
No.
Only, my lord, in fact, not preliminary, as my friend says, preliminary examination was conducted, called application. More than, my lord, 2 lakhs applicants have appeared. Out of that, 1,30,000 applicants have applied for examination. After conducting an examination, my lord, we have issued, my lord, released the key answers. My lord. Thereafterwards, large number of applicants have objected and, my lord, they protested for there are some mistakes and error in the question paper itself. One question objective type, my lord, there are 4 answers. Answers are wrong. Taking into consideration, my lord, the commission has, my lord, referred the matter to the subject expert committee. Expert committee have found that there are some lapses and error in, my lord, the preparing, my lord, the question papers. Therefore, the report was not submitted to the government as well as also, and the commission unanimously taken a decision to conduct a fresh review. As the examination was conducted, the result was, this is a preliminary examination. Thereafter, after publishing, the results, after scrutinizing, then the main exam will be conducted. My primary contention before my Lord is maintainability of the writ petition. Lord, the provisions of Lord, Your Lordship, kindly see section 15 of the Karnataka Administrative Tribunal Act. Lord. Section 15, it provides may I read, my Lord? Jurisdiction, power and authority of the State Administrative Tribunal.
So this is for the main exam.
This is a preliminary exam, my Lord.
Preliminary.
Prelims exam, Lord, 15, my Lord. Jurisdiction, power and authority of the State Administrative Tribunal, save as otherwise expressly provided in this Act. Administrative Tribunal for the state shall exercise on and from the appointed day all jurisdiction, power, authority accessible immediately before that day, all courts except Supreme Court in relation to, my Lord, a recruitment. My Lord, I'll stop here. This is matter pertaining to recruitment of provisional officers gazetted A and B. If the recruitment is not the selection process is going on, then the Karnataka Administrative Tribunal has got a jurisdiction to entertain and decide the issue. Therefore, approaching directly, bypassing the tribunal, filing writ petition is not maintainable. The 7th bench of the Honorable Supreme Court, in the case of L. Chandra Kumar and one division bench and single judges of this Honorable Court, opened that so far as recruitment is concerned, the party has to approach Karnataka Administrative Tribunal. And one minute. Supreme Court L. Chandra Kumar versus Union of India. But para 93 is relevant for 93 and 99. But page, it starts page 308.
Yes.
Para 93. Before moving on other aspect, we read, bro?
Yes.
Before moving on to other aspects, we may summarize our conclusion on the jurisdictional power of the tribunal. The tribunal are competent to hear the matter where the virus of the statutory provisions are questioned. However, in discharging this duty, they cannot act as a substitutes for the High Court and the Supreme Court, which have, under our constitutional setup, been specifically entrusted, which with such an obligation, the functions of this aspect is only supplementary, and all the decisions of the tribunal will be subject to scrutiny before the division bench of the respect to high courts. The tribunal will consequently also have a power to test the virus of subordinate legislation and rules. However, this power of the tribunal will be subject to one important exception. Tribunal shall not entertain any question regarding the virus.
Yes.
Please.
Sorry.
Once again, from 93 announcement. Once again, I'll read. Before moving on to other aspects, we may summarize our conclusion on the jurisdictional power of these tribunals. The tribunals are competent to hear matters where the virus of statutory provisions are questioned. However, in discharging this duty, they cannot act as a substitute for the High Court and Supreme Court, which have, under our constitutional setup, been specifically entrusted with such an obligation. Their function in this respect is only supplementary, and all such decisions of the tribunal will be subject to the scrutiny before the division bench of the respective high courts. The tribunal will consequently also have the power to test the virus of subordinate legislation and rules. However, this power of the tribunal will be subject to one of the important exceptions. The tribunal shall not entertain any question regarding the virus of their parent statute following the settled principles of the tribunal, which is created of an act cannot declare that very act to be unconstitutional. In such a cases alone, the High Court concerned may be approached directly. All other decisions of these tribunals rendered in the cases that they are specifically empowered to adjudicate upon the virtue of their parent statute will also be subject to the scrutiny before the division bench of their respective high courts. We may, first instance, in respect of the area of law for which they have been constituted. By this, we mean that it will not be open for the litigant directly to approach the High Court even in cases where they question the virus of the statutory legislation, except as mentioned, where the legislation which creates the particular tribunal is challenged by overlooking the jurisdiction of the tribunal concerned. But next, my lord, 99, my lord. In view of the reasoning adopted by us, we hold that the clause 2D of Article 323A of Article 3D of Article 323B to the extent they exclude the jurisdiction of the High Court and Supreme Court under Article 226, 227 and 32 of the Constitution are unconstitutional. Section 28 of the Act and the exclusion of jurisdiction clauses in all other legislations enacted under the aegis of Article 323A and 323B would to be the same extent be unconstitutional. Jurisdiction conferred upon the High Court under Article 226 to 27 and upon the Supreme Court under Article 32 inviolable basic structure of our Constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform supplemental rule in discharging the power conferred 226, 227 and 32 of the Constitution. The tribunals created under Article 323A and 323B of the Constitution are possessed of the competence to test the constitutional validity of statutory provisions and rules. All decisions of the tribunals will, however, be subject to scrutiny before the division bench of the High Court, within whose jurisdiction the tribunal concerned falls. The tribunal will nevertheless continue to act like a court. For instance, in respect of the areas of law for which they have been constituted, it will not, therefore, be open for the litigants to directly approach the High Court, even in cases where they question the virus of the statutory legislation, except where the legislation which creates the particular tribunal is challenged by overlooking the jurisdiction of the tribunal concerned. This is the Supreme Court judgment, my lord. Then 11th single judgment, my lord. Kumari Jayasri, my lord, case. Para 6, my lord. But page 11, my lord, there is one citation mentioned, not the page 11. Ganesha and other sources to brand. Thereafter, where this court has held that the administrative tribunal, as per section 15, shall exercise the jurisdiction, power, and authority in relation to recruitment and matters concerning recruitment to any civil service of the state or to any civil post under the state. It is also held therein that the validity of the rules in a matter relating to the civil service of the state can also be gone into by the tribunal. Even in the applicants to the post being a prospective candidate for the civil posts under the state who are denied the chance of applying and competing for appointment of the post could as well maintain application challenging the rules. Thus, it is his contention that the petitioner can avail a remedy before administrative tribunal and the writ petitions are not maintainable. Para 6, I have heard the learned counsel appearing for the parties. The essential grievance made by the petitioners is directed against the action of the respondent Kpsc, incorporating the clause in a notification inviting the application inter alia providing for exemption from passing a national eligibility test in respect of the candidates who have completed MPhil by 31/12/93 or who have submitted PhD thesis in the concerned subject up to 31/12/2002. Petitioners claim that they have also completed MPhil, though subsequent to the cutoff date, namely 31/12/93, and they should also be exempted from rigor of passing the national eligibility test. This is essentially a grievance that can be the subject matter of the adjudication before the Karnataka Administrative Tribunal, having regard to the facts that the post for which the notification is issued is that of the lecturer in the government colleges. The relevant clause incorporated in the notification is pursuant to the amendment brought about as per the Karnataka Education Department Services Collegiate Education Department Recruitment Amendment Rules 2002. Rule 6 of these rules provides for a cutoff date which is reflected in the notification inviting application. Therefore, grievance of the petitioner in the essence is against the notification and the rules framed. Merely because the challenge is incidentally made to the notification issued by the UGC, it cannot be ground entertain this petition as the main grievance is directed against the action of the respondent Kpsc, which is traceable to the recruitment rules framed. Therefore, reserving liberty to the petitioner to approach the Karnataka Administrative Tribunal to air their grievances, these writ petitions are rejected as not maintainable with no order as to cause. The similar view was taken by the division bench, the next Lingam case following the Supreme Court judgment regarding para 13 and 14. Page 27. Page 27, para 13.
Yes.
It is submitted that the Karnataka Administrative Tribunal started functioning from 1810-2000. Since the tribunal has started functioning, in our view, these petitions will have to be decided by the tribunal in the first instance. The Supreme Court in L. Chandra Kumar's case has held that the tribunal are only courts for first instance in respect of the areas of law for which they have been constituted, and the decision of the tribunal will be subject to the scrutiny before the division bench of the respective high court. 14 more. The Supreme Court has also held that if a matter is decided by the tribunal, it will serve two purposes. While saving the power of the judicial review of the legislative action vested in the High Court under Article 226 of the Constitution, it will ensure the frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have a benefit of reasoned decision on merits, which will be the use to it in the penalty deciding the matter. But in view of this, the law laid down by this Honorable Court and the Honorable Apex Court, but the present treaty petition filed by the petitioner before this Honorable Court is not maintainable. So far as the merits are concerned, 29th is a date. We have prepared the examinations, re-examinations, and the centers have been identified, and the question papers also as on after rectification of the defects, we have made all sincere efforts and holding the fresh the examinations. If the prelims examination, we require to conduct a fresh after getting the report from the experts who said that there are some mistakes, error committed in the question paper itself. 4 questions, they have given the key answer. For example, the one of the key answers, I will mention this the question paper itself. Page 119. Page 119. One example, question number 51, page 119. Page ಕನ್ನಡ 51. ಭಾರತದಲ್ಲಿ ನಾವು 3 ಮುಖ್ಯ ಬೌದ್ಧಿಕ ಪರಂಪರೆಗಳು ಎಂದರೆ ನಿಗಮ ಪರಂಪರೆ, ಆಗಮ ಪರಂಪರೆ ಮತ್ತು ಸಮಾನ ಪರಂಪರೆ ಕಾಣುತ್ತೇವೆ. ಆನ್ಸರ್ಸ್ 4 ಆನ್ಸರ್ಸ್. ಎ, ನಿಗಮ ಪರಂಪರೆಯು ವೇದ ಎಂಬುದಾಗಿಯೂ ಕರೆಯುತ್ತಾರೆ. ವೇದಗಳನ್ನು ಸನಾತನವೆಂದು ಅಥವಾ ದೇವರ ಬೋಧನೆಗಳನ್ನು ನಂಬುತ್ತದೆ. ಆದರೆ ಅವುಗಳ ಆಧಾರ ಗ್ರಂಥಗಳನ್ನು ನಿರಾಕರಿಸಬಹುದಾಗಿದೆ. ದಿಸ್ ವರ್ಡ್ ನಿರಾಕರಿಸಬಹುದಾಗಿದೆ is absolutely incorrect and it is English it says page 100 A my lord, tradition of Nigama, also known as the Veda, believes that the Vedas are either eternal or the teachings of the God, but their authority is challengeable. What the English is, authority is challengeable. Here nirakarisabahudagide, that is wrong.
It's not challenging.
It is. Not only this, my lord, another my lord, important my lord, Vidhana Sabha, instead of Vidhana Sabha, Vidhana Parishattu, my lord, one more, my lord, the questions, my lord, page number 125, my lord. 125. Question number 59, my lord. ಕ್ವಶನ್ ಇಸ್ ರಾಷ್ಟ್ರೀಯ ಕುಟುಂಬ ಆರೋಗ್ಯ ಸಮೀಕ್ಷೆ 5 NSF ಗೆ ಸಂಬಂಧಿಸಿ ಈ ಕೆಳಗಿನ ಹೇಳಿಕೆಗಳನ್ನು ಪರಿಗಣಿಸಿ. These are all the answers. One, C, I'll directly take C. ಕರ್ನಾಟಕದಲ್ಲಿ ಸರಿಸುಮಾರು ಪುರುಷ ಮತ್ತು ಮಹಿಳೆಯರು 15 ರಿಂದ 49 ವಯಸ್ಸಿನ ನಡುವೆ ಇರುವ 30ರಷ್ಟು ಇದ್ದಾರೆ. Here, English page 126, item 59, C, in Karnataka, nearly 30% of men and women between 15 to 49 years of age are overweight or obese. ಕನ್ನಡದಲ್ಲಿ ಈ ವರ್ಡ್ ಓವರ್ವೇಟ್ ಇಲ್ಲ.
One submission. Friend is asking about. This should clarify. Notes 59 question my friend read. 59 is in English. Notes I will take my notes page number 232 for a moment. These are the key answers. Notes which my friend is reading that answer. That is totally incorrect answer. Correct answer is that is the fourth. I will take my notes page number 232 for a moment.
One submission. I'll finish. This answer which is correct, it is a mind of the applicant within a fraction of second. He has to within 1 ನಿಮಿಷದಲ್ಲಿ ಒಂದೊಂದು ಮಾಡ್ಕೊತ ಹೋಗ್ಬೇಕು. 100 ಆನ್ಸರ್ ಇರ್ತದೆ immediately. He can't read both immediately. Simultaneously fraction of second ಅಲ್ಲಿ ಆನ್ಸರ್ objective type ಮಾಡ್ಕೊತ ಹೋಗ್ಬೇಕು. Therefore, the person who appeared, there is created confusion in the mind of the students also, and the expert says there is a wrong error. Therefore, expert says these are all the questions. Answers are directly not the correct translation. Therefore, opinion that the commission took a decision to conduct a fresh examination and taking clear the correct English and translation question papers and redo the examination in a fresh. So far, we have conducted the examination, given key answers. Then key answers, they have filed several numbers of students have submitted an application, the objections. In view of their objections, commission taken a decision to conduct a fresh examination. If the examination is conducted, the petitioner as well as more than 2 lakhs of the applicants are entitled to take part in the examination. Then we will announce preliminary key answers. Then thereafterwards, we will call for objections, revised key answers. Then we will conduct for fresh exams after announcing the prelims examination. Therefore, present writ petition filed by the petitioner is one ground is not maintainable, and the commission has already taken further steps for conducting fresh re-examination and scheduled to be held on 29. And all arrangements have been made by the commission. At this stage, only 2 persons, one before this honorable court and one is before the principal bench. Here, my lord has granted the interim order. Their principal bench, no interim order was granted.
What is the interim order?
No, sir, that is annexure M is state.
M is state.
No, sir, I will take for a moment.
The conducting of
Notes immediately I rushed to the court and this order was questioned before this purpose. Last 15 days, since from that date, still today there is interim stay. My friend submits for this order, all the arrangements are done. when there is an interim order before this honorable court. If really they were inclined to conduct this exam immediately, they could have moved before this honorable court for vacating. Notes, this petition is one. Bangalore is filed note subsequently that is pending that we could not, only my friend has produced. Notes, my friend has filed a statement of objection. In the statement of objection, my notes, there is not a single ground is asked regarding maintainability of writ petition. I will take my notes to for a moment, my notes, statement of objection. Notes, from paragraph number 2 onwards, nothing is, my notes, regarding maintainability of writ petition. For the first time, my friend has made a submission. I am not saying. So that is, for a moment, I will take notes. Even in their statement of the objection, they admit, as per the direction, my lords, of the CM only, they have issued this notification. And further, my lords, one more contention, my lords, which they are contending, lords, around 130,000 students have appeared for exams. Lords, how many have appeared in the English exams? How many have chosen for Kannada exams? That has been not forthcoming in the statement of objection. Even according to Annexure 1, my lords, R1, which, my lords, for a moment you peruse it, which they say, my lords, as per this, even in this, my lords, they never disclose what is the expert committee report has disclosed. If expert committee reports come on the record, my lords, it could be revealed what is the, my lords, exact has taken place.
How many students have taken the exam?
Lords, according to their statement of objection, it is 130, lords. Lords, 131,885. At paragraph number 4 of the statement.
So this is prelims.
Please. Lords,
And
230,000
results
students.
are not announced.
Result is not announced.
Not announced.
So how many have objected and filed complaint with regard to
No,
therapy?
lords. It is nothing. It is for, lords, the respondent has to
Have you filed statement?
Yeah, I filed statement.
nothing is
What
disclosed.
have you stated? How many of them have objected? How many are having objections with regard to there being confusion in this Kannada and English version?
Nothing is mentioned in the statement of objection. I will take my notes to the paragraph number 2 for a moment of their statement of objection.
ಇಲ್ಲ ಅದರಲ್ಲಿ regarding maintainability.
Maintainability ಎಲ್ಲಿ ಬರುತ್ತೆ? Not all mentioned regarding maintainability. They have alternative remedy. Nothing is specified in their statement of objection.
Heading itself regarding maintainability.
Regarding maintainability, but I have not stated regarding the tribunal and
Tribunal,
but regarding maintainability, I have stated.
That entire para is read out.